Hello, my name is Michael Perlin. I'm a professor of law at New York Law School, where I direct the online mental disability law program and the International Mental Disability Law Reform Project that's part of our law school's Justice Action Center. I've been to Taiwan 5 times, most recently in April of this year when I gave lectures at National Taipei University and at National Tsinghua Law School. And while in Taipei, I had the good fortune to meet and speak with Hannah Chen. And I am so grateful that Hannah asked me to speak to you all via this video conference link. As you are watching this, it is now 11 p.m. in Halifax, Canada, where I have come to make a presentation to the Canadian Psychological Association, and I'm sure I am fast asleep. But if you have questions, please submit them to Hannah by email, and I will do my best to answer them what is tomorrow afternoon for me and what will be late this evening for you, the wonders of technology. The title of my talk today is Sexuality and Mental Disability, American and International Human Rights Perspectives. I have spent almost 40 years involved with mental disability law as a legal practitioner, as an advocate, as an academic, and as a scholar. And through my career, one thing has been clear. Nothing has ever touched as raw of a nerve as has my talking about the question of whether or not persons with mental disabilities have a right to voluntary sexual interaction, especially when such individuals are institutionalized. Why was this? And what did this have to do with what I call saneism, an irrational prejudice of the same quality and character as other irrational prejudices that cause and are reflected in prevailing social attitudes of racism, sexism, homophobia, and ethnic bigotry that permeate all aspects of mental disability law and affect all participants in the mental disability law system: litigants, fact finders, counsel, and expert and lay witnesses. Here's what I said about this several years ago. Society tends to infantilize the sexual urges, desires, and needs of persons with mental disabilities. Alternatively, these people are regarded as possessing an animalistic hypersexuality, which warrants the imposition of special protections and limitations on their sexual behavior to stop them from acting on their, quote, primitive, end quote, urges. By focusing on alleged differentness, we deny their basic humanity and their shared physical, emotional, and spiritual needs. By asserting that theirs is a primitive morality, we allow ourselves to censor their feelings and their actions. By denying their ability to show love and affection, we justify this disparate treatment. I believe that this insight best explains the difficulty that so many of us have in dealing with this issue and explains why policymakers are often unable to approach these issues thoughtfully, even-handedly, and with clear heads. Once when I spoke about this in Florida, an audience member leapt to his feet and he exclaimed, "Professor Perlin, you are an agent of the devil." In New Jersey, someone said, "Professor Perlin, I will pray for your soul." Why did my talks elicit these responses? Today I'm going to be talking along these lines. First, I'm going to discuss competence to sex in matters involving persons with mental disabilities. Then I'll discuss it in the context, briefly, of marriage and in the context of sterilization. Then I'll consider the impact of international human rights law in the very specific situation of the recently ratified UN Convention on the Rights of Persons with Disabilities, and will then conclude with a few thoughts and recommendations. First, let's turn to the question of sex and psychiatric institutions. Now, before we can analytically approach the question of whether institutionalized persons with mental disabilities have the right to engage in consensual sexual activity, we have to engage in some modest deconstruction. No doctrinal or theoretical formulation can be seriously undertaken until we articulate our perspective. Are we looking for a legal answer, a clinical answer, a social answer, an administrative answer, or a behavioral answer, or, as we should, a combination of all of these? Sure, we must consider each of these areas of analysis if we wish to construct a meaningful, multi-textured, and comprehensive response. Let me first consider the legal implications of the subject, and I'd like you to think about some questions. I don't have the time in the context of today's talk to answer all of these. I just want to raise them to share and I hope inspire some of you to think about these as well. When you send me your questions on email, I can send Hannah the names of some articles that I've written, and I'll send her copies of those articles so she can send them on to you as well. So here are the questions. To what statutorily or judicially defined civil rights are involuntarily committed mental patients generally entitled? In the articulation of such rights, have the courts or the legislatures specifically considered sexual autonomy or sexual interaction rights? In the United States, will the Americans with Disabilities Act force public institutions to change how they treat patients in this context? Is it necessary to inquire individually and initially into an individual patient's competency to make sexual decisions? And if so, how is this determined? Do competent institutionalized patients have the same autonomy rights as all other persons, allowing them to engage in the same level of sexual self-determination as non-institutionalized persons? Putting aside inquiries into mental capacities, are all patients to be treated the same way? Or are there differences between voluntary and involuntary patients that are relevant to this inquiry, civil patients and forensic patients? Should involuntary commitment in and of itself implicitly restrict one's freedom to engage in sexual activity? Is it justifiable or even legally required to place different restrictions on patients who have been committed following their involvement in the criminal justice system than those imposed on civilly committed patients? And within the former group, is there a relevant difference between patients awaiting trial, patients determined by a judge to be permanently incompetent to stand trial, and those patients found not guilty by reason of insanity? Is there a relevant difference between patients who have been found to be incompetent for any reason and those who have not? Next, we should turn our attention to clinical questions. For example, has the patient in question ever expressed any wish either to engage in sexual activity or to abstain from it? Is it clinically beneficial or is it anti-therapeutic to allow institutionalized patients autonomy in sexual decision making? In answering this question, to what extent ought we consider research on the therapeutic value of touching and physical intimacy? Should the projected length of a patient's hospitalization affect the restrictions placed on their sexual autonomy? If so, how? What is the impact of sexual activity on different methods of treatment, on the overall ward milieu? What correlative responsibilities come with the assertion of rights? Next, we must consider the practical implications of sexual relationships in a closed institution like a psychiatric hospital. Under the best of circumstances, entering into a new sexual relationship can be stressful and confusing. Are these stresses inappropriately, and I put quotes around the word inappropriately exacerbated when the universe in question is that of institutionalized mental patients? To what extent should the differing stress management abilities of institutionalized individuals be factored into any policy that's ultimately adopted? Conversely, can preoccupation with sex systemically distort all matters involving ward behavior? How does this focus affect questions of individual needs versus group needs? Might an excessive concern with sex blunt the consideration of other related issues, such as self-esteem, the importance of developing a full range of interpersonal relationships, and the ability to deal with intimacy? A closed institution, by its very nature, places substantial limits on individuals' mobility and their freedom of action. When people in the, quote, free world, end quote, terminate a stormy love affair, frequently they can adjust their lives so as not to have very much contact with their former lovers. What happens if that ex-lover lives on the same floor of an inpatient hospital, especially if it is a locked ward hospital, and neither patient can leave without a court order? Conversely again, what happens when a couple is split up by a court order, transferring one patient to another ward or a different facility for clinical reasons or for legal reasons? In any event, can patients be stopped from having sex? Are there worthwhile analogies that can be made here to rules that were supposed to govern college dormitories in the 1960s and the 1970s, when administrators vainly and futilely tried to suppress sexual activity among undergraduates? Is it realistically possible to monitor sexual practice in a facility such as a psychiatric hospital so that an individual patient's exercise of the right to sexual autonomy does not result in non-consensual sex, in unwanted pregnancies, or in the spread of sexually transmitted diseases. This leads us next to a consideration of these issues from the perspective of hospital officials. Why are hospital administrators almost universally resistant to expanded sexual activity on the part of patients? Is it more than simple inconvenience or even the fear of unwanted pregnancies? How much does a fear of a potential hospital-wide AIDS epidemic contribute to this resistance? And how realistic is that fear? How much of this fear is inspired by genuine clinical concerns for patients in their care? The expansion of provider liability is a source of realistic concerns on the part of therapists that an ever-expanding range of clinical decisions may lead to ever-expanding professional and personal liability. And one commentator has even suggested that the threat of litigation has led hospital administrators to, quote, attempt to minimize the complexity of patient sexuality issues by focusing on the symbolic, simplistic reassurance of written procedures, end quote. Was this response idiosyncratic to the circumstances that the hospital discussed there, or is this practice more common? How does the whole question of sexual autonomy in a public institution fit with the resolution of other social, cultural, political issues, such as age reporting or condom distribution? Even if policies are promulgated that protect and respect the sexual autonomy of institutionalized individuals, what happens when individual line staff at a hospital, the people to whom the implementation of a policy inevitably falls, simply refuse to cooperate with the policy because their own sense of, quote, religious morality, end quote, forbids it? For example, their religion may teach that unmarried persons of any mental capacity should not have sex, or that married persons of any mental capacity should not have extramarital sex. Is it justifiable for private facilities that are church-affiliated or private non-sectarian facilities that retain units especially designated for practitioners of specific religions to apply different restrictions in these areas? This list of questions, which is incomplete, should underscore the point that this topic is very complex. And its complexity is confounded by society's generally irrational attitude towards persons with mental disabilities. This general lack of attention, litigation, and commentary on the subject appears anomalous. Institutionalized persons self-evidently don't lose their sexuality or their sexual desires when they lose their liberty. And there's some added irony here to be founded in the fact that litigation over antipsychotic medication refusal, which is the most contentious aspect of institutionalized patients' rights law that is frequently litigated, that centers on drug side effects. Loss of sexual desire is one of the most highly noted drug side effects. So thus, the law acknowledges that sexual desire is a sufficiently important trait so that its diminution must be weighed into the formulation of a medication refusal policy. Yet the law simultaneously denies the power and importance of sexual desire with respect to hospital ward life. Most states do not recognize patients' right to personal or interpersonal sexual relationships. In practice, a patient's right to sexual interaction often depends on the whim of line-level staff or on whether such interaction is seen as a feature of the patient's treatment plan. It has even been suggested that, again I'm quoting, sexual activity between psychiatric inpatients should be strictly prohibited, and when it occurs, patients should be isolated and tranquilized if necessary. One hospital's guidelines counsel patients as follows, quote, if you develop a relationship with another patient, staff will get together with you to help decide whether this relationship is beneficial or detrimental to you, end quote. Hospital staff is often hostile to the idea that patients may be sexually active in any way. However, many institutional mental health professionals and behaviorists now recognize that patients are and wish to be sexually active, and that sexual freedom often has therapeutic value. Others call attention to our societal obligation to provide family planning assistance to women institutionalized in psychiatric hospitals. Nonetheless, many hospitals remain reluctant to promulgate such policies. This is not surprising, given the aforementioned paucity of legal authority requiring them to do so. Moreover, there is a near complete lack of literature generally available to guide hospitals and their staff should they even desire to formulate such procedures. There have been almost no cases litigated on this topic. There is very little statutory law in place in the United States and elsewhere. Although many American jurisdictions have enacted, quote, patients' bills of rights, providing a broad array of civil rights and liberties for persons institutionalized in psychiatric hospitals, only a few jurisdictions mandate a limited right to sexual interaction. Which leads logically to the next question. Since we in America are, by all accounts, a fairly litigious group of people, why not? Why hasn't this area, one that deals with the most personal of rights, been the subject of greater scrutiny or of court decree, or even of substantial scholarly writings? There has been attention paid to this in the nursing literature and to a lesser extent in the psychiatric literature. But there's been virtually no carryover to the question of the legal implications of our policies or lack of policies. We also need to consider, how do we set priorities in defining the underlying question? What do we look at first? Autonomy rights, civil libertarian concerns, due process requirements, privacy interests, competency criteria, clinical needs, therapeutic jurisprudential concerns, tort liability worries, voluntariness constructs, or the immutable fact that sexual interaction, by its very description, entails the participation of more than one individual. No resolution of the underlying issues can be contemplated unless we sort out these approaches and carefully articulate their interrelationships, their potential conflicts, and their relative values as competing social choices. In short, this is a very, very difficult project. Excuse me. Now I'm going to turn my attention to an issue that is less controversial, but no less important. What issues are raised when we think about an individual's competence to enter into marriage? Time limits prevent me from spending much time on this issue, but I want to make a few points. In the United States, marriage is a fundamental right guaranteed by the 14th Amendment to the U.S. Constitution. Although the state may impose reasonable requirements if they pose no significant interference with a marital relationship, substantial interference with a decision to marry is permissible only if important state interests are at stake and the regulation is closely tailored to effectuate the state's interests. Consistent with constitutional guarantees, the statutory requirements for marriage are minimal. Every marriage requires capacity on the part of both individuals to enter into the relationship. This stems from the conception of marriage as a contract as well as a social status. What about the mental capacity to marry? Well, as in other areas of civil law, individuals are presumed to possess the capacity in the absence of a determination to the contrary. Moreover, a presumption of validity applies to marriages, reflecting the state's interest in promoting and protecting marriage and family. The best accepted standard for mental capacity to marry is whether the individual understands the nature of the marriage contract and the duties and the responsibilities that it creates. The language of this standard parallels the capacity standard for ordinary contracts, but the meaning is quite different due to the vast differences in the responsibilities and consequences of marriage as contrasted with ordinary business transactions. As one court described it, marriage in many cases depends more on sentiments of mutual esteem, attachment, and affection, which the weakest may feel as well as the strongest intellects, than on the exercise of clear, unclouded reason or sound judgment, of intelligent discernment and discrimination, and in which it differs in a very important respect from all other contracts. Few cases specify what an individual must understand about the, quote, nature of marriage or the attendant duties and responsibilities to satisfy the marriage capacity standard. A contractual perspective would suggest that the material provisions of the marriage contract would define the understanding required for capacity to marry. Cases eschew such a formalistic approach, instead emphasizing the fact-specific nature of the capacity determination. As in the case of other capacity doctrines in the civil law, capacity to marry need exist only at the time of marriage. Proof of a mental disability that ordinarily compromises the capacity to marry will not invalidate a marriage that is entered into during a, quote, lucid interval. This is another means by which courts can enforce the policy of preserving marriage. Now, this very short overview leads to a couple of other sub-issues deserving of attention. What about claims of incapacity? Well, claims of incapacity to marry arise in three basic contexts. One spouse seeks annulment after a period of living with the other spouse as husband and wife. Two, a guardian or a family member seeks annulment during the lifetime of the spouses. And three, a guardian or family member seeks annulment after the death of one of the spouses. Because of time limitations, I can't discuss these in depth now, but again, I will be happy to answer any questions you may have about these if you send me via Hannah an email later. Let me turn my attention now to the question of sterilization. Several courts have weighed state constitutional provisions, along with their federal counterparts, in cases involving petitions for involuntary sterilization of minors or incompetent persons, and have found both the right to be sterilized and the right to autonomy in sterilization decision-making to be protected by such provisions. By way of example, the New Jersey Supreme Court first recognized that although a right to sterilization had not received express constitutional protection from the U.S. Supreme Court, several lower courts had found such a right, that it was included in the privacy rights afforded by the federal Constitution. The court also found this might be protected under the state constitution. Governmental intrusion into privacy rights may require more persuasive showings of a public interest under our state constitution than under the federal constitution. In one case, the California Supreme Court found that state legislation that absolutely forbade sterilization of persons under conservatorship deprived developmentally disabled persons of their privacy rights under the state and federal constitutions. The court also found the right of a woman to choose whether or not to bear a child, and thus to control her social role and personal destiny, was a fundamental right under the state constitutional provision that could be restricted only by a compelling state interest. Other cases have discussed a circuit court state constitutional right to rule on the petition of a guardian seeking to have an adult daughter with mental retardation sterilized, and have found that a trial court of general jurisdiction had broad parens patriae power over incompetent persons, enabling it to act on a petition seeking sterilization filed by the guardian of a non-institutionalized adult with mental disabilities who had Down syndrome. On the other hand, the Colorado Supreme Court held there was no clear and convincing evidence to show that a woman with mental disabilities was unable to grant or withhold consent to sterilization, and the state constitutional law issue was not reached. In a later case, the Eighth Circuit Federal Court of Appeals found that if proven, the allegations that state social workers had compelled a mildly retarded woman to submit to a tubal ligation rose to the level of a due process violation. The most important development in recent years has been the publication of Professor Paul Lombardo's brilliant book, 3 Generations, No Imbeciles, Eugenics, the Supreme Court, and Buck v. Vell. Finally and definitively, this book gives the lie to the facts misfound in Justice Holmes' infamous 3 generations line in the Buck opinion, which he said, 3 generations of imbeciles is enough. It is my hope that Professor Lombardo's book will reach the general public and society's ordinary common sense on this question will finally change. I do not know if this book is available in Chinese. It certainly should be. Anybody who is interested in sterilization and the eugenics movement, this is far and away the best book that has ever been written. Right, I'm going to change my focus now for my last few minutes from domestic issues to international issues. In recent years, I have turned more and more of the focus, my focus, to the relationship between international human rights law and mental disability law. How does this connection play out in the context of what I am discussing here? I believe that the ratification of the United Nations Convention on the Rights of Persons with Disabilities demands that we reconsider this entire issue. Now, when I was in Taiwan in April, I spoke about this convention several times. I understand the issues in Taiwan, that you are not, unfortunately, a member of the United Nations, and UN conventions are, of course, not binding on you. But I believe that Taiwan should act in accordance with this convention. I believe this is the best practices in this area. This convention mandates nations, and I'm going to quote this directly, to provide persons with disabilities with the same range, quality, and standard of free or affordable health care and programs as provided to other persons, including in the area of sexual and reproductive health and population-based public health programs. Beyond that, the convention articles mandate respect for inherent dignity, the elimination of discrimination in all matters related to interpersonal relationships, and in the provision of services in the area of sexual and reproductive health. Yet the literature has been remarkably silent on this issue in general, and has been totally silent about the issue that I will discuss in my paper, the CRPD's impact on the rights of persons institutionalized because of psychosocial or intellectual disability to sexual autonomy. Professor Michael Stein and Janet Ward have recently written eloquently about how another article in the convention, Article 30, setting out social rights of participation in cultural life, quote, serves as a vital channel of engagement with such society when such participation is accommodated in the community and increases, quote, self-reliance and empowerment. Other commentators have concluded that the convention, quote, is regarded as having finally empowered the world's largest minority to claim their rights and to participate in international and national affairs on an equal basis with others who have achieved specific treaty recognition and protection. If the convention is taken seriously, if it is in fact more than a paper victory, then perhaps it can be a vehicle to uproot that aspect of sanism that continues to deny the sexuality rights of institutionalized persons with mental disabilities. Next summer, I'm going to be giving a presentation at the International Academy of Law and Mental Health in Amsterdam in July of 2013, specifically on this issue. I am turning my research focus now on the relationship between the CRPD and sexuality rights. I hope that other scholars, both in China, in Taiwan, in the United States, in Europe, in other parts of the world, do this as well. So given all of this, what are my conclusions? First, it is clear there is no unitary definition of competency in this matter, in this area. Often there are no definitions, and when there are definitions, they're often circular, and frequently they are contradictory. Second, there is a whole range of issues to be considered in determining, quote, sexual competency. But as the cases and materials that I have discussed should make clear, these factors change from case to case, from jurisdiction to jurisdiction, and from substantive topic to substantive topic. Third, this remains so under-discussed because we are still so astonishingly uncomfortable thinking about the questions at hand. We want to close our eyes to the reality that people with mental disabilities are sexual beings, and we want to close our eyes even more to the fact that their sexuality may be much more like ours than it is different. Fourth, I am hopeful that the new UN convention finally will make us reconsider how myopic we continue to be about these issues and realize that sexuality rights are rights that must be enforced. Those of you in the audience who know me, and I expect I do know several of you, know that I'm a huge fan of the singer Bob Dylan. In his magnificent song, Desolation Row, he sings, quote, but all his sexless patients, they're trying to blow it up. Society wishes patients were sexless. They are not. We need to deal with that reality. In the past 4 decades, a sexual revolution changed the way we think about gender, about sex roles, about personal relationships, and sexual expression. The last 3 decades have seen a legal civil rights revolution affecting the way we think about persons with mental disabilities, both in institutional and community settings. The last 2 decades have seen a revolution in the joining together of the international human rights movement and the mental disability law movement. Perhaps now we can finally devote to this area of policy the attention it deserves. It's about time. Thank you very much.